Okay, we will proceed to the second matter, which is Stuart versus the people. That's number 5 of 2023.
Mr. Chief Justice, and may it please the court, Kele Chukwuchidi Onyejekwe. I represent Viviane Stewart. I will reserve 5 minutes for rebuttal. However, I will also reserve waiver of rebuttal following the government's argument before this court this morning, if it pleases.
Well, again, I'm not sure.
I would like to reserve
5 minutes.
5 minutes.
But
I would like to reserve the ability to waive that 5 minutes after I've heard from him. What he has said.
Sure. So if he doesn't say anything that bothers you, you can just waive it?
Yeah, I just waive, unless the court has questions.
All right.
My client was charged with murder as a principal. In the information at the end of the facts, where the government accused her of participating in the actual stabbing of the victim, the government added that there was aiding and abetting. And according to the government, this is notice to my client that she was also charged with aiding and abetting. We get that, we will live with it for now. We have 4 reasons, however, why this court must vacate Stuart's convictions, her conviction, with instructions for the Superior Court to dismiss the information in her case. The first one, I think, does not require much argument. There was no unanimity in the verdict convicting her, arising from the instruction that the court gave. The instruction to the jury in this case permitted the jurors to decide whether or not to convict her of murder, convict her of aiding and abetting murder, or for nothing at all. She would be convicted if anybody on earth killed the victim that night under this instruction. And you ask, how does the jury find her guilty then? The government added some more explosive, inflammatory information throughout the trial. One is insurance. They said she collected insurance soon after the death of her husband.
Oh, you said what?
Well, the government argued throughout the trial that she is guilty of murder because she collected insurance, life insurance.
I think it is more than that. Have you looked at a calendar of 2005, June of 2005?
I haven't looked at the whole calendar, but I took notice of the dates.
June 22nd is a Wednesday. And she came and she went to, according to the testimony of the young lady from the Division of Personnel that takes care of these insurance business. There was a 75 plus 5, that's 80,000 split between the son and Miss Stuart. She went in on the 29th, so which means that she filed a claim within 5 business days of her husband's death or husband's murder. The rapidity with which that was done seems to suggest that while you argue that there is no testimony that she knew of the existence of the policy, but gee, because remember now, we have an intervening Saturday and Sunday between the 22nd and the 29th of June 2005. And Division of Personnel, a government office, is not open is not open on Saturdays and Sundays. So doesn't that seem to suggest that that's before even that he was perhaps might have been buried or something? She had knowledge about this policy, and so much knowledge that she went and she filed a claim.
Thank you very much for that. That's exactly the sentiment the government wants us to have.
Yeah,
And
you see, take that because remember now, this is a circumstantial case, and the jurors got a jury instruction that said there are two types of evidence: circumstantial evidence and direct evidence. You are entitled to consider both kinds of evidence, but how much weight or credibility you give to any evidence is for you to decide. And so it's not only the insurance policy, but all the other aspects of the evidence in the case, particularly the lovey-dovey relationship between Mr. Kajus and Mrs. Stuart. According to the testimony of a whole lot of thing in the record. So, to go in within 5 business days to claim an insurance policy from the government, I don't think the jurors might take very kindly to they probably didn't believe that she didn't know that the policy existed.
Here. I'm sorry, were you about to?
yes,
I'm sorry.
I thank you for the comment, but that's the problem. Every court that has looked into this issue, this is the issue of, not in civil cases, but in criminal cases, when the government says A killed B.
Right.
It's because usually the evidence will show.
You try to stand in the mic so that
The evidence will show that there's some type of conspiracy. If you kill this person, you get 10%, you get some benefit,
right,
monetary or not. In this case, the government forgot something. Between June the 22nd and June 29th, the government was not open. But there was something that was open, the funeral homes.
What? You said that the
Stuart
government
is
was not
saying
open?
that she got this information from the funeral homes, that her husband might have insurance. Because when somebody dies, they try to bury them. And they go to funeral homes. And that's exactly what she did. They don't go 1 week after or 10 years after. They go as soon as they can. They got this information from the funeral home. The government's witness testified that the families and the government gets the information from the funeral home.
All I'm simply saying is that she could have known, or whether she get it from the funeral home, or whether she get it from a co-worker, or from anybody, since she was a government employee. But all I'm simply saying is that she didn't waste any time in going in to claim under the life insurance policy. Her husband was just murdered brutally, and the money isn't going anywhere, but she didn't waste no time in going and claiming. All I'm simply saying is that that is one aspect of the web of circumstantial evidence, in this case, I guess, that the government was promoting. But that alone in isolation, I would agree that insurance, life insurance alone is not enough, but that just add to the web of circumstantial evidence in the case.
What you would like this court to, you would like this court to adopt the doctrine that the people have to prove that the alleged assailant, the defendant, knew about the insurance policy before the act. That's what you
Yes,
are
before
advocating.
death.
Okay,
And not
can we get back to unanimity or lack of unanimity for a minute?
Yes,
Okay,
please.
because you started to argue that,
But
but then you,
would the court give me a little more time to address the more important thing for
But
us?
see, you
The
pick-
issue,
okay,
You pick your time and you decide you want to.
the issue that there's zero evidence, there's zero evidence of my client's guilt. Based on the government's own argument. The government says, ladies and gentlemen, I'll be candid with you. This is a circumstantial evidence case. And they say, the government told the jurors as well, if somebody dies, and there is no sign of forced entry into the premises, two things are possible, 50-50. Either the person in the home let them in, or the person from outside had keys or used some type of ruse to get the person inside to open to open the house. And I looked in the past 20 cases on this issue where there is no sign of forced entry, there's been no case where somebody is found guilty of murder and the government did absolutely nothing to negate the other 50%. Traditionally, it used to be said that if you're going to find somebody guilty on a theory of circumstantial evidence, then you must negate, the government must negate the defendant's theory of innocence. Here, the government tells us, it's right there in the transcript, I think it's page 1211, it says there are two things. Either the person inside opened it or somebody outside came in. They concentrated on the fact that somebody may have come inside. So what is the theory of innocence? How do they negate that theory of innocence? Actually, this thing has nothing to do with a key. No phone records were checked. And don't forget, at page 30 of the government's own brief before this court, the government cites a June 29th call by a concerned citizen who tells us that he told police that there was a third key. Now, don't forget the court made this finding. The Superior Court made a finding that there are only two keys. This is central to the conviction.
Who had the third key?
According to page 30. And he referred to that conversation, and I filed a copy of what transpired. And two things, he cited one thing that transpired, the adulterous relationship, but he said two things there, and that there was a third key that Kajus had been walking around with. At trial, so I asked the people who tried the case what happened, what they say, hearsay. But now, this is a declaration by party opponent. It's not even hearsay. It's an exception to hearsay. So there's a third key properly before you. How does that square with the court's finding that, there are two keys, Viviane had one, and the victim had the other? Justice Cabrera, please may I answer the question regarding...
yeah, regarding lack of unanimity. Yes. Why are you arguing that the jury returned a verdict that was not unanimous?
Because there may have been confusion over these years, but this year, in two cases, the U.S. Supreme Court held that if you're going to find somebody guilty of aiding and abetting, you must show that somebody has committed a crime. And the way to show that somebody has committed a crime is to find by the judgment of 12 people or a judge in a bench trial that they committed a crime. And another person aided and abetted this crime. Nothing in the Virgin Islands Code has just one provision defining a crime. And that definition of a crime, I think, is 14 VIC 4. has not been amended. It's still there. So you need 12 people to find that a crime was committed. In this case,
You don't think the evidence, the circumstantial evidence showed that that Mano was killed, stabbed to death with a knife in his neck, that a crime had been committed? You don't believe that the evidence shows that?
yes, I believe that the evidence is clear that a crime was committed, I think. But the instruction does not require the jury to find that any particular person committed it. However, the problem with the instruction, and there is no other instruction like this, in the brief of the government, or that I can see
Did
anywhere.
anyone object to the instruction? Wasn't this instruction actually put together by defense?
There was a conference. There was a
conference.
There was a jury conference.
An in-depth conference.
All day.
Almost all day, yes.
Yeah, an in-depth conference.
The public defender came up and stated the correct statement of the law. Cajust stated the correct statement, and then they went back and forth. And I think towards the end, both sides got tired. And when the court came up with...
So, but what do we do with that?
Yeah.
What do we do with that? If you have two parties, they're at a day-long conference, they helped the trial court invited them to submit instructions. The trial court went through the instructions word by word on some of them almost, invited their participation, and there was no objection by Mrs. Stuart. So what is an appellate court supposed to do with that? And now you argue plain error, so tell us where the error is, because that's the only way you're getting to us, by plain error.
The error is one. The court always, the Constitution requires that you need 12 people to commit a crime and be convicted, a jury. And that jury has to be unanimous. The jury is unanimous when 12 people vote for a proposition. And in this case, they didn't. And that's the error.
What did they vote for? That's what I'm trying to find out from you. Why are you saying there's a lack of unanimity?
It is a lack of unanimity because some people voted for Stuart. Some people voted for the fact that she may have actually committed the murder by stabbing as charged. Some people voted that she may not have participated in the stabbing at all. And that has become a...
Sorry, if she did not participate in the crime at all, that would have been a vote for an acquittal, which did not occur in this case.
Well, an acquittal is impossible because of the trial, the instruction, because the people who disagree with that fact, they were not unanimous, and the people who agreed with that fact were not unanimous.
Okay, what I hear you arguing is that, I'm just going to pull out numbers. 6 persons could have voted to find her guilty as a principal, and 6 persons
Exactly.
could have voted to find her guilty of aiding and abetting.
Exactly.
Does that matter under our law?
Yes, it matters under our law.
Why?
How?
How?
Does it matter?
Yeah.
Because under our law, you have to have 12. You have to have 12 to have a crime.
But they were polled.
Yes, they were
And
polled.
all of them said that
This
this is my verdict, individually.
When people in
All
almost
the jurors were polled, and the jurors responded. There wasn't a negative vote in the polling of the jurors' verdict.
they're right to do so.
Well, Attorney Keeley,
Yes.
if the jury found her guilty of aiding and abetting, she is guilty as a principal, correct?
But
I mean,
no.
that's what the law says. She is.
Yes,
As a
but
principal.
12.
If they find her actually committing it, She's also guilty as a principal. So what difference does it make, and why is it not unanimous in this case?
It's not
Based
unan-
on the law, including the law
First
from
of
this
all,
court.
the law of this court is clear. The law of this court is the same thing as the law of the United States Supreme Court. It differs from Chad. Chad versus the United States, the cases from California that the government wants you to adopt. First of all, if there was no debate, if there was no divide, the government would not be asking you to adopt the theory that if it's aiding and abetting, even though there's no majority showing that a crime was committed of the jury has not found that a crime was committed.
If they found her guilty of first-degree murder, isn't that evidence that they found that a crime had been committed?
Ordinarily, it would. In Chad, in all these in the cases cited by the government, it would. But what I did is I looked at the actual instructions in those cases. For example, in Chad, the jury was not given any instruction in the disjunctive. They were not asked to choose between A or B. So they had no choice. In Chad, they found the defendant guilty, not in the disjunctive, but
Okay.
they found him
Thank
guilty.
you. You've got 10 minutes and 33 seconds over. So,
Thank you.
Good morning, Your Honors. Assistant Attorney General Ian Clement on behalf of the people. We've established that, let me just say that Mr. Kajus's blood was found at the crime scene. It was found mixed within the blood, or his DNA was found mixed within the blood of the victim.
this is a Stuart case now.
I understand that, Your Honor. I understand that. But the question remains, how...
Find Stewart's DNA and anything?
No, but the question remains, how did Mr. Kajus's blood get there? How did he get in? After the event, after the crime, Ms. Stuart was interviewed by the police. She testified, she stated in her statement, which is Exhibit 13, that there were only two keys, only two sets of keys. Her keys and her husband's set of keys. Detective Phipps testified that there are 3 locks on that door. They have had a 4-year-old autistic child. They're very particular about locking the door for obvious reasons. She stated in her statement that when she left that night on the 21st, 11:35, she locked the door. She left her son and her husband within the condo. When the police came the next morning, they found Mr. Mano's keys there on the counter. So both sets of keys were accounted for. I'm not quite sure what counsel is talking about on page 30 of my brief. There was no third key. There was no third key talked about in my brief. There was no third key
He is
presented.
saying that someone could have knocked on the door, Mano came and opened the door, and therefore the keys issue is not relevant.
Well, the jury is instructed that it cannot make up evidence. There's no evidence of a third key. There's no evidence of anyone knocking on the door.
I'm not talking about a third key.
Pardon?
I'm not talking about a third key. I'm simply talking about, someone knocking on the door,
Right.
a person inside letting them in, and therefore the key is irrelevant.
Well, the evidence presented at trial was that there were only 2 sets of keys.
I understand
And
that.
the court must view the evidence.
That's not the question.
I understand it, Your Honor. The court must view the evidence in a light most favorable to the people, right? So the scenario that you're presenting, though plausible, is not evidence.
Why it's only plausible to me, that's the way you get into a home is if you don't have a key.
Right. Well, Your Honor, you have to also take into account the other elements or the other evidence in this particular case, and that is the actions of Ms. Stewart while all this was going on, the night that when she arrived at work, and after, right? So she had a very particular routine when you get to the Emerald Beach Resort. You come in, you go to the front desk, you sign a log, right? She does that every single time. When you come out, you sign a log to sign out. This particular time, she didn't come in and just sign a log. She took the entire log with her outside. That's something that she had not done before. Ms. Toussaint, who was the night auditor, testified about that. Another thing that she had done only on this particular night was that her entries in her activity report, as it would, were very particular, as if she was there every single hour. The custodian of records for Ranger American testified that that's not the way it's usually, her reports usually show up. And so you could see.
But how is any of that a substantial step towards wanting the murder, assisting in accomplishing the murder?
Right, well, you have to look at all of it, right? So she changed her routine that way. She changed her routine with respect to, she would usually come into the lobby and stay with Ms. Toussaint towards the end of her shift. She didn't do that. She usually leaves at 7 o'clock in the morning because she has to go take care of her autistic son. She didn't do that. She came back in at 7:15. Now, when she testified, when she did her statement to the police, she states that she left her home, which is upwards of Banco Popular, instead of driving down to Veterans Drive and going to the right towards the airport, towards the hotel,
What was the theory of the government's case? Was it that Cajuste committed the murder and that she aided in abetting him by giving him the keys to get in?
She provided access that no one else could, because there was no tool marks on this door. There was no evidence of forced entry. So more than likely, and you had more than one lock. You had a deadbolt and other locks on this. So you very much had to, the evidence that was presented to the jury was that there were only two sets of keys. That's what she said in her statements.
So why didn't you charge her on that basis rather than charging that she actually committed the murder, or else, well, she helped someone else do it?
Well, she was charged.
Is it hard for her to defend not knowing whether or not she's being charged with actually committing the murder or simply assisting?
Are you asking if she was on notice of that?
I know you got Section 11 and you said aiding and abetting, but I'm saying, he is saying that you have not proved who committed the crime. You're simply saying someone in the world committed this crime and she aided and abetted. So how can we judge what did she do to aid and abet this unknown person in the world commit this murder?
Well, it wasn't an unknown person in the war, Your Honor, because.
But why didn't you charge that? Why didn't you charge Cajuste with murder in the first degree and charge her with assisting him, rather than charging them both with committing it or else aiding and abetting each other?
Or aiding and abetting an unnamed person.
Well, this court has said in time that the people need not have named the individual who committed it or who aided and abetted.
Eventually, in the first amended information, she's charged as an aider and abettor.
Yes.
The first degree murder.
Right.
So somewhere along the way, the original information was amended, where now she become an aider and abettor. But you look at the circumstances in this case, his DNA, where his DNA showed up, because the problem is once they're tried together, the jurors heard all this DNA evidence against Mr. Cajuste.
Right.
And they heard about the relationship with Mr. Cajuste, because Ms. Toussaint said that even on his days off, Mr. Cajuste would come there and spend time with her, even though she was working. Now, what is telling is that the log, the person from Ranger American, the log shows that she was there and at 12 o'clock, 1 a.m., 2 a.m., 3 a.m., 4 a.m., 5 a.m., 6 a.m. But here is the rub. It's in her handwriting. She's the one that vouched to say that she was there. Nobody else says that this is a log that they put in the information and saw her and vouching for it. That's number one. And what is also telling is that when Mrs. Toussaint was, she said that she noticed that despite the security camera, she was driving what appears to be a white rodeo. And that white rodeo was, she saw it coming in to the parking lot sometime during this time. So she must have left in the rodeo and went somewhere. But she was apparently not always present at the front desk with Miss Toussaint. There was a period of time that Miss Toussaint is saying, no, she was not there. There was one time when Miss Toussaint testified that there was a guest that they were looking for her and they couldn't find her. Yet still she seems to make the allegation that she was present. But that's a self-serving statement. And what they would say to cook the books, apparently, because those notation in Ranger American notebook as to her being present, it's all in her handwriting. She was the one that vowed and said she was there. But what is telling is that Ms. Toussaint said that she couldn't, why did she have to take up the book from where it customarily is and go with it?
Yes, Your Honor.
Probably to fix the books.
Exactly, Your Honor. So these, courts have held that.
But not only that, who was the female voice that the people downstairs heard? Mr. DeCastro, I believe is his name. He said that, we heard a thumping song upstairs. We don't know what was going on, but it sounded like it was going on like a struggle. We heard voices. One was a female voice and a male voice, but we could not discern what was being said. But one thing is absolutely certain. It's a male and a female that was in that apartment during the time, and apparently it was not the voice of Mr. Mano. Because as Ms. Toussaint said, Mr. Kajus had a distinctive accent, I believe, a distinctive voice. And he would call her several times, but when you look at the relationship that they had, the two of them, when you look at the movement of the two of them, and when you look at all this other evidence, whether that was the knife in the drawer that the Rodriguezes saw, or whether it's the same knife or whatever, one thing is absolutely certain. The one that testified, the one Rodriguez's brother, he said that even though his mother is deceased and even though his mother might have told him that, and that could be excluded, well, he of himself testified that, well, I didn't see the knife after that. But where was this knife? In the drawer, the dresser drawer, in the room that was occupied with Mr. Kajus, her co-defendant, and who is charged equally with her with this murder business. And all that, you take all of that into consideration, and when the knife showed up, it never was seen after that, according to him. So even without his mother's testimony, even if we discount that, this is all a circumstantial case. But it doesn't matter that it's circumstantial. It is how much weight the jurors give to any evidence in the case, including circumstantial evidence. But all I can see is that there seems to be a pattern of circumstantial evidence that led to that could have led to this murder, particularly her reaction when Detective Phipps showed up and wanted to talk to her. Her husband is in there on the ground; he's dead, and she seemed to be ignoring him. He wanted to talk to her, and so I mean, it's circumstantial evidence, yes, but there's nothing wrong with good old-fashioned circumstantial evidence if it's as good as gold, and you can that you can connect the dots. What about the relationship between Mr. Kajus and Miss Stewart?
Well,
What kind of relationship that they had?
we know that they, or the jury could infer that they had a relationship that was just more than a work relationship. Mr. Kajus would come.
Wasn't it casual friends or casual acquaintances?
No, the jury could infer by the fact that Mr. Kajus would come and stay with Ms. Stewart during her shift. Now, keep in mind, her shift is between 12 midnight and 7 in the morning, when most normal people would be asleep. This is a relationship that went beyond that.
Yeah, I don't know of too many people who's just gonna go and keep somebody's company in the nighttime when they are working as a security guard from 12 to 7, gonna come on the job site to keep their company. That's sleeping time, particularly when, even though he was working for the same company, he was off. Many people on their off days and whatnot, they're not gonna come on the come and see to keep anybody's company. But who is it that said that they were seen on perhaps on the beach or driving around or certain things of that sort?
That was in relation to the defendant's arguments regarding lack of notice, and the arguments presented that the probable cause affidavit was part of the information that put the defendant on notice as to all the allegations and charges that would be presented to let her know that there's more than just what's in the information. Here's a probable cause affidavit that shows that people are saying, hey, they're having this open and notorious relationship. It's not a secret, and that it was out there. My time is almost up, but I will say one more thing about her reaction. It was not just her reaction that her husband had been brutally murdered. Keep in mind that this happened where her 4-year-old son was also present. Keep in mind that the people downstairs heard this ruckus in the middle of the night, and so it's reasonable for the jury to have inferred that the 4-year-old child was there, was awakened by this, and witnessed this murder. Keep in mind that, and keep in mind and contrast that with
What does it have to do with?
well, contrast that with her reaction in the morning, where she's on the phone, where she doesn't seem to be bothered with the police, and so on and so forth. I think that's not a normal reaction of someone whose husband has just been murdered, whose child has just witnessed this crime. Keep in mind also her varying stories to the police as to where she went, that she drove all the way over to the Polyberg area where Mr. Kajus lived. She did that before her shift. She did that after her shift. These are things that the jury were able to consider in conjunction with.
Is this heritage, where's the gas station that is being talked about across from the high school? Is that the one where those houses that were across from Wild Plaza?
The one, I believe, the one in Polyberg, that one I believe is now painted orange. It's the Alibaba. I think that's the one that they're referring to now. That's the one by the Charlotte Amalie High School. I see my time is up. I would submit that.
Okay, well, thank you. I think
Okay.
just wrap it up, whatever you want.
Yeah, I would just say that based upon all of the evidence presented at trial, the court properly found that any reasonable jury acting in good faith could have found Ms. Stewart guilty of murder in the first degree, aiding and abetting, and it properly found and it properly denied the defendant's motion for judgment of acquittal.
In other words,
Okay,
you want
thank
us to find that circumstantial evidence is as good as gold?
Yes, Your Honor.
Thank you. Attorney Keeley, you wave or you I knew that you weren't going to wave. That was just that was a gimmick.
I begin with two decisions of the United States Supreme Court this year: United States versus Hansen, criminal; Twitter Inc. versus Tame. Two cases stand for the proposition.
Were these cases in your brief?
They were my reply brief, but they're briefed. The issue is there's been confusion whether or not we go with the common law the common law requirement that if somebody is aiding and abetting a crime, the prosecutor must prove the crime. Over the years, it watered down to what has become in California, where the prosecutor says aiding and abetting, and six jurors find aiding and abetting, six jurors find a crime. But both the US Code and the Virgin Islands Code says there's only one way to commit a crime, violation of these sections. There's only way to violate these sections. There's ways determined by a judge in a bench trial, in a jury trial. So I think the aiding and abetting jurisprudence of this court is something the court will ultimately have to look at as more courts comment on these two cases that came down this year. With respect to, he said he doesn't know what I was talking about at page 30 of our police brief. This is what I'm talking about. On June 29th, 2005, a citizen called the police and told the police the following, that this person is aware of a relationship between Cajuste and my client, and that's one thing this person said, and that's how the government cited this June 29 discussion, the call from this citizen to the police in the brief. It's there on page 30. So I looked up, I said, where is this? What does it say? And lo and behold, it says two things. There's this adulterous relationship, and number two, that Mr. Cajuste had been walking around with a spare key. The government never investigated this. This is not hearsay. We will live and die with this fact in this case. There's a third key. We can't wish it away. That's
Who said there was a third key?
a concerned citizen called the police and said there was a third key. And the trial court did not reach this issue for good or bad reasons.
Did a concerned citizen come forward and really testified about this third key?
The police advised the caller to have this concerned citizen come forward. The government listed a person that usually assists the police, Dantan Shoot, in its witness list. We thought he would show up. This court has commented about his reliability. The government did not produce Dantan Shoot at trial. So but then the question, it's the government that raised this issue. The government cited this conversation. It only cited half of it. I filed the entire conversation by notice to this court before this hearing. So it's there. So regarding the law of circumstantial evidence, when evidence is circumstantial, it's good as gold, as Justice Swan has said, but the government must negate a theory of innocence of the defendant. In this case, in the past 20 cases, unanimously that decided issues where there is entry, no sign of forced entry, there's a 50-50 chance that somebody inside opened the door, or somebody who has a key penetrated the residence. When this happens, the government has an obligation to show that it is not entirely the person.
This was your original argument. No,
Yes.
no, it's not rebuttal now.
Well, I cited a number of cases, but two cases from Florida Supreme Court, Wright versus State and Hodgins versus State in my brief. These cases are analogous to the ones before us, in which people were charged with aiding and abetting or in the same type of circumstance. And the court found insufficient evidence to convict and reversed because, Number one, the government did not do anything in those cases to negate a theory of innocence of the defendant. And that's my case.
Thank you.
Thank you very much for having me.
Thank you. The matter will be submitted. Okay, we'll go to the final matter.